Let's bring in now attorney and legal analyst Janet Johnson. Janet, thank you so much for giving us some time today. Let's just talk about the evidence in this case. It has been repeatedly called damning. There are details and photographic evidence included in the indictment. How much of an impact, Janet, can that have? And are we likely to see more evidence if this does go to trial? Because, again, we're talking about classified documents.
Yeah, no, I mean, that's definitely going to be something that's going to be litigated. You know, I heard someone say earlier they put the strongest evidence in the indictment. I will say, practicing in Florida and in federal court in Florida, that is not necessarily true. I think they put just enough information in the indictment to get to court. Obviously, this was a grand jury, heard this evidence and returned these charges. But there will be other evidence that hasn't been put in the indictment, either because it is too classified or because they just don't have to do it at this point. And I will say, when you walk into federal court, the odds are stacked very heavily against you. I mean, they don't just, willy-nilly charge people with 37 counts in federal court. They have their ducks in a row. And not to say that the defense won't, but the odds will be stacked against Mr. Trump.
Okay, let's bring in now as well former federal prosecutor Andrew Cherkasky. Andrew, thank you so much for joining us on this panel here. So, Andrew, Judge Eileen Cannon, she is a Trump appointee. She was overruled by the appellate court. She's back in charge of this case. Will she, in fact, remain in charge?
I think she'll remain on this case. She seems to have not disqualified herself the last go around. Just because you're overruled on appeal has little effect ultimately on whether or not the judge can stay on the case. So it's not an unordinary situation. So I think she'll remain on unless there's something specific that we don't know at this time.
All right. Well, Jen, I want to kick it back over to you. I mean, how much time could the former president face if convicted? And if he is elected again as president, could he just pardon himself if he is convicted? I mean, or couldn't he just tell his attorney general, hey, end the case, because he's the president?
Well, I mean, there's a lot going on there. He's looking at 100 years, essentially, if you add up all of the counts. One of the things that I think we have to keep in mind is it's not unprecedented to see these charges brought to court, but you would look at other people who are sentences, if he's convicted, other sentences for similar crimes. And, someone was just sentenced a couple weeks ago, a military aide received 3 years, I would say, for facts that weren't as egregious as this. But, if I, as a defense attorney, I would be arguing, yeah, he's looking at 100 years, but, his age, again, this all assumes a conviction. Whether he can pardon himself, if he is convicted under the Espionage Act, I think there is a legitimate question as to whether he can serve as president. I suppose under his theory, he can do whatever he wants as president. That's why we're here, essentially. He said, I can declassify things in my own head, even though he admitted on these tapes that, we're going to hear in court, that is not the case, and he did not, in fact, do this. I would suspect if he's convicted and he is reelected, then all bets are off. He will, again, do something lawless, because that is who he is. That's why we're here.
And we're taking a look now at new sketches just into NewsNation here. This is what it looked like inside that Miami courtroom today. You can see a sketch of the former president there standing with his legal team, as well as in front of the judge during today's arraignment. Andrew, back over to you. I mean, talk about the likelihood, as a former federal prosecutor, talk about the likelihood of a plea in this case and what that could look like.
Well, there's no chance there's going to be a plea in this case other than not guilty. I mean, not only am I a former federal prosecutor, but I'm also one of just a few people who have actually tried these cases. And what I'm talking about is a mishandling of classified document case before a jury. And so I've seen what it's like to actually defend a case like this. This is going to be a deep question when you look at the elements and you start questioning the idea of, was this actually an unauthorized document that Trump had? There are deep questions that the Supreme Court has not answered in regard to a president's authority to have these documents. The document that was just referred to with the admission that it was a classified document, they don't have that document. There are deep issues with all of the functions. And I want to point out one last thing. The charge timeframe starts on January 20th of 2021, the day Donald Trump left office. That's before any of the demands came from the National Archives. It's before the subpoena. It's before the FBI demanded these documents back. So when you look at this constitutionally, you have to look really deeply at the idea that they are far way away from getting a conviction at this point. There are many months ahead, much more evidence that has to come out before I'm convinced that a jury is going to vote beyond a reasonable doubt.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.